Hi everyone, and a very warm welcome to today's SME Club meetup. For those of you who've not met before, my name is Jen Quinn and I'm Growth Manager at Virgin Money Manchester. We are delighted to be sponsors of today's event. Like many of you, we're working from home at the moment, but it's lovely to still be able to communicate and deliver events to support our local business community. Our key focus at Virgin Money at the moment is to ensure that our customers are supported. Information on the support offered can be found on our website, and we'll be sharing that link with you following today's event. Please do feel free to get in touch with me or any of the team if there's anything else that we can help you with. We'd love to hear how you found today's event. Please do tag us in your social media posts. We're at Virgin Money on all social platforms. And just finally, today's discussion topic is essential commercial legal information to manage your business during the COVID pandemic. Chris Keane of Clarke Willmott will be chairing today's panel. So for now, I'll hand over to Chris and look forward to catching up with you soon.
Chris, you're on mute.
Good morning. Let's try that again. Good morning. I'm the insolvency partner at Clarke Willmott. My name is Chris Keane. I'm just going to give you some thoughts on where I see the pandemic and from an insolvency perspective and what it's going to look like out the other side. So as matters currently stand, it looks to be the calm before the storm. The Covid-19 pandemic has not produced the landslide of formal insolvencies that was expected. Indeed, insolvency appointments are well down, with many companies surviving by utilising the rescue packages created by the Treasury. This is mainly due to the alleviation of traditional pressure points, HMRC, landlords, banks, general creditors pressure, for example. So the usual pressure points would be HMRC. At the moment, the HMRC enforcement is relaxed. There are policy changes which mean that the HMRC aren't enforcing as strictly and as hard as previously. There is an increased sympathy on the time to pay proposals and their deferment of VAT. And with regards to the pressure from landlords, it's going to be curtailed as a result of the Corporate Insolvency and Governance Bill. Under the bill, if enacted without amendment, landlords cannot rely on a statutory demand served after the 1st of March. They're invalid, and this will continue till 30th of June this year, with the possibility of a further extension. Further, landlords will not be able to present a winding up petition until at least 30th of June 2020. Okay. Statutory demands and winding up petitions, which might normally be utilised during such a time frame, would be in many instances inevitably include liabilities going back many months and often more than one quarter, i.e. well before lockdown. The main reason that the corporate insolvency appointments are down is just simply due to the rescue packages created by the Treasury. There is a degree of zombie company about it, insofar as there are going to be companies that are wholly and completely insolvent and ought to be put down now, but as a result of the rescue packages that are there, they will continue to slow down until at least the 1st of August. So in addition to that, there are the grants and coronavirus business interruption loans, which are preventing insolvency as well. They're there to ensure that businesses who are able to meet their liabilities should do so. There appear to be few checks and balances in place, and it's likely that a lot of this money won't actually be used as the government intended and or be well spent by its recipients. Again, you've got the furlough scheme, which we're all aware of, recently extended till October, with employers expected to move some contribution to the scheme from, with employers expected to make a contribution to the scheme from the 1st of August. In practical terms, the extension of the furlough scheme will mean that we will not see the first large tranche of corporate insolvency appointments until at least August, really. The weaker companies that simply can afford to make the 20 or 30% contribution, whatever's decided, to the furlough scheme will have no alternative than to seek professional insolvency advice at that point. Assuming that the government doesn't extend the furlough scheme beyond the 31st of October, we could actually see a tsunami of formal insolvency appointments through November and December. So then that takes me on to the Corporate Insolvency and Governance Bill, which is currently before Parliament. So this bill is going to, just headlines on this, so I appreciate we've got limited time. So dealing with statutory demands and winding up petitions, the bill is going to prevent the presentation of winding up petition for the period 27th of April to 30th of June, so until 30th of June, unless the creditor has reasonable grounds to believe that the pandemic has not had a financial effect, or that the debtor would have been able to pay its debt regardless of the pandemic's financial effect. It's a really low threshold, and it's going to be difficult for creditors to prove the negative, to show that a company could effectively, the company can pay but for COVID. It's a strange situation. Additionally, no winding up petition can be filed after the 27th of April 2020, arising as a result of creditor failing to satisfy statutory demand between 1st of March and 30th of June. There is temporary suspension of liability for wrongful trading. It limits the wrongful trading provisions from the 1st of March to the 30th of June, until the month after the bill comes into force, whichever is later. Now, personally, I don't think this has a huge impact. The temporary suspension of liability for wrongful trading has no impact on the director's duties that they owe to the company in the Companies Act. It doesn't impact the rules in relation to fraudulent trading or director's disqual. And in actual fact, wrongful trading is the most difficult claim to run at the best of times. So putting more hurdles in the way of obtaining an order for wrongful trading isn't really where the focus should have been, in my view. I think maybe relaxing corporate governance rules might have been more sensible, but that's just my view. There is also a new part of the bill, which is the moratorium. The bill proposed this is a permanent measure going forwards, where the directors in insolvent companies or companies likely to become insolvent due to Covid-19 can obtain a period of 20 business days statutory moratorium, which purely to allow them to restructure or seek new investment. So essentially it's a rescue provision. So then what do I think post-lockdown, what's the landscape going to look like? Well, as most of the support is in the form of debt or deferral of debt, businesses are just effectively delaying the inevitable, and just in the hope that they can make the payments and prop up the business post-lockdown. The furlough scheme is currently due to fund on the 31st of October, which will leave employers back on the hook then for their salaries. So unless there's demand rockets when lockdown ends, I imagine many companies will struggle to find the necessary funds to pay the deferred VAT or repay the CBIL loans, or or any of the other liabilities which they may have kicked into the long grass. Also, decisions are going to have to be made about whether to retain furloughed staff to meet salary requirements or make redundancies. It's highly likely we'll see a wholesale increase in insolvencies, certainly beyond the end of the furlough period. So we'll see liquidations for those weaker, cash poor companies that be forced into liquidation as the embargoes on creditor action end. We'll see pre-packs or CVAs for the other viable businesses that seek to get rid of some of the debt, remove some of the debt. And what we will see is a huge increase in vulture funds or investment funds seeking to acquire businesses on the cheap. So we're going to also see, I believe, an increase in claims brought by liquidators and administrators, certainly in relation to some of these loans that have been improperly used by directors. There's just no checks and balances in place, and I believe that there's going to be an awful lot of litigation off the back of that. I think there'll be a huge tranche of actions in relation to recovery of directors' loan accounts, general misfeasance claims, and then obviously with the creditor pressure the way it is, there'll be, I think, an increase in uptick in claims such as preferences, transactions at an undervalue, and general breach of director's duty claims. So whilst the insolvency market appears to be relatively calm at the moment, I think exiting the lockdown and ending the furlough scheme, we're going to be looking at a very, very busy period of time, certainly from October through to the end of the year. But if there's any assistance that you require in relation to that, feel free to contact us. I think my contact details will be put up at the end. But now I'm passing on to Anna Youngs, who is a partner in our employment team.
Good morning, everyone. So yes, as Chris said, my name's Anna Youngs. I'm a partner at Clarke Willmott and I specialise in employment law. I think it's safe to say that employers and employees have been affected by coronavirus. That's probably somewhat of an understatement. Some businesses have been busier at this time, particularly food manufacturing and food retail. Other businesses have sadly seen a sharp decline in trade, as Chris has mentioned. Many businesses have had to adapt to new ways of working, and this creates a challenge for many of us. But today I'm just going to spend a few minutes looking at what's next in the sphere of employment. So furlough. Chris has mentioned the government's furlough scheme, whereby employer and employee agree that the employee won't do any work for a period of time. The employee will continue to be paid a proportion of their salary, and then a grant is available from government to help employers to pay that proportion of wages. The government's indicated that the scheme will continue as is until the 31st of July this year, but from the 1st of August, the scheme is changing. We're waiting details for what that will look like, but it's intended that the scheme will become more flexible. Some part-time furloughing will be allowed, that's currently prohibited. And it may be that some employers who haven't yet been able to make use of the furlough scheme because they've needed staff, albeit at a reduced rate, will be able to make use of the scheme for the first time. We don't know yet. However, employers will be required to share the cost of furlough. We don't know yet whether a contribution to the cost will be required even where the employee does no work. But many businesses won't be able to afford to contribute to furlough pay. So sadly, redundancies are on the cards, and that is something that a number of my clients are thinking about at the moment. There are a number of steps that an employer must take if you're seeking to dismiss someone fairly for redundancy, and you'll be familiar with steps such as getting the pooling right, applying fair selection criteria, consulting with employees, and looking for alternative employment, which may be difficult at this time. But where an employer is considering making 20 or more redundancies within a 90-day period, then you might have to consider collective consultation obligations, which means minimum information to be provided to representatives and minimum periods before you can dismiss employees. If you get that wrong, there are costly penalties, so that might be one area where you'll need to think about getting advice. If the furlough scheme as we know it is ending on the 31st of July, employers need to be thinking now about what they're going to do with their staff after that date. It may be that you need to terminate by the end of July if you can do that, because you can't afford to contribute to furlough pay if that's required. So the government say they're going to let us know this week what the furlough scheme will look like from the 1st of August. So next week might be a good time to start thinking about whether redundancies are necessary. Rather than redundancies, some businesses might be getting ready to bring staff back from furlough or back to the office after a lengthy period of home working. So you'll all be aware of the social distancing requirements where staff are working on site together. There's specific guidance for specific types of workplace, which you will need to be familiar with. If you Google COVID secure and the government, then you'll probably find that guidance. You should be telling your staff what steps you have taken to protect their health and well-being at work. You should be providing hand washing facilities. There should be signs up reminding people to wash their hands and telling them what you've done to protect them. You'll need to undertake risk assessments. You'll need to tell employees you've done risk assessments, and you'll need to have considered whether you can put various other measures in place. As well as all of those things, we might need to start thinking about the impact of annual leave. The government will allow carryover of statutory leave for up to 2 years where the employee has not been able to take their leave because of coronavirus. But that gives rise to the question, well, when is an employee prevented from taking their leave because of coronavirus? Could they take it now? Do you want all your staff to take their leave or a proportion of it by a certain time in the year? Does the employer want to allow staff to carry over any leave, and if so, how much? we've got to remember that annual leave isn't about going away somewhere, it's about a break from work. So to what extent can we just require staff to take leave now? And employers have always had the right to require staff to take leave at a set time with particular notice. These issues need some thought so that employers don't find all their employees taking leave at the same time later this year, or employees with far too much leave over the next 2 years. Finally, whilst many of us want to get back into the workplace, to get back to some sort of normal and the cut and thrust of normal life and interaction with our colleagues, some employees really don't want to go back to the workplace. Supporting staff who are vulnerable is of course a must, but employees who are frightened but not higher risk might need some encouragement to come back to work, and we might need to think about what that looks like. Working from home is still the government's preferred first option. Many businesses have made home working work. So as we move forward, there may well be an increase in permanent, flexible or home working arrangements. It might be harder to refuse requests for home working going forward. And so we need to think about those things as well as we move on to the new normal. So that's just scratch the surface really of the sorts of employment issues that we're experiencing at the moment. If you want any more detail, do get in touch. But for now, I'm going to hand over to Ed Tennant. Ed.
Good morning, everyone. Thanks, Joanna. I'm a commercial property partner, so I'll be talking commercial property. I'll be doing a brief canter through where we stand in terms of landlord and tenant issues throughout lockdown, and then finally, if we've got time, give you my brief thoughts about our return to the office and what the office will look like. Obviously, with a vast majority of employees working from home, one of the first overheads that tenant occupiers have looked at is the cost of their premises, and in particular their rent. It's important to stress that no legislation enacted or contemplated includes any release of a tenant's obligation to pay its rent under the lease. There are, however, measures that have been brought in by the government to assist tenants in this difficult period. First, in relation to forfeiture, under the Coronavirus Act 2020, a landlord is prevented from forfeiting a lease for non-payment of rent until at least the 30th of June 2020. There's nothing that prevents a landlord from forfeiting for breaches other than non-payment of rent, but a landlord in those circumstances as a Section 146 procedure and allow a reasonable period of time to pass before forfeiting a lease, and the court is likely to give quite a lot of leeway to tenants as to what a reasonable period of time means. Commercial rent arrears recovery, actually known as CRA. On the 24th of April 2020, the government introduced regulations to restrict the use of CRA to cases where the rent is more than 90 days overdue. Court proceedings, no prohibition on commencing court proceedings. However, money claims are not seen by the courts as being a priority at the moment, so it may take quite some time for court proceeding for rent arrears to be dealt with. Stat demands and winding up petitions. Chris explained these much more clearly than I could, but very briefly in terms of landlord and tenant, it will prevent a winding up petition being presented where the landlord relies on a statutory demand served between the 1st of March and the 30th of June. And as Chris mentioned, in terms of winding up petitions themselves, it places the burden on the creditor rather than the debtor to have to prove that the company's failure to pay its debts was not caused by the coronavirus pandemic. So quite a high bar for a creditor to have to get over. Rent deposits, nothing that prevents a landlord from dipping into rent deposits. Getting a tenant to top that back up is another problem altogether, but obviously check the terms of the rent deposit deed as to what the process is and whether the landlord is able to dip into the rent deposit. Frustration is a funny one for us property lawyers. That is where an act happens that is outside the contemplation of the parties. That means that the lease can't continue. It's very hard for that to prove under the terms of the lease. In 2019, the court said that Brexit was not a frustrating event. And in 2004 in Hong Kong, the SARS pandemic was not seen as a frustrating event. It's unlikely that frustration or the current pandemic will be seen as a frustrating event to bring a lease to an end. It's once a landlord and tenant do agree terms in terms of rent concession, rent holidays, rent deferments, it is important that those are set out in writing and are legally binding. Otherwise, you could be storing up issues further down the line. Things to think about, whether you're landlord or tenant, in terms of agreeing those terms are these terms going to be personal between your landlord and the tenant, or are they going to bind successors? So if the landlord sells its building, will the buyer be bound by that? A tenant will say yes, a landlord may say no. Are the terms to remain confidential? A landlord may not want a tenant telling the other tenants of the building what it has agreed with its landlord, and forcing the landlord to agree those, even if the other tenants are in good financial health. How long should the arrangement last for? Especially with the a phased ending to lockdown, you need to be precise as to when those particular office building is back to normal, and the lease arrangements as they were, we go back to that situation. Is it a rent reduction or a rent postponement? I need to be clear on that. There might be a misunderstanding between landlord and tenant. Is there a rent review taking place during the concessionary period? Perhaps not a huge point, unlikely to be upwards rent reviews at the moment, but just one to think about the impact on that rent review. And then finally, perhaps most importantly, is there a guarantor of the tenant's obligations under the lease? Because if the guarantor does not consent to those terms agreed between landlord and tenant, the guarantor could easily argue that it's been released of all obligations under the lease to guarantee the tenant's obligations. So one to think about. Other knotty problem is break clauses. If a tenant's looking to break a lease at the moment, two considerations. Conditions to the break. A lease may set out what the conditions to the lease break are, be it a tenant having to provide a vacant possession, or having to remove certain kit from the premises, which might be problematic in terms of accessing the premises or getting contracting to do that. Other point is in terms of notices as well. Hey Charlie, this is my son Charlie. Yes, notice provisions under the lease itself, whether how the notice is served. It might be very prescriptive. Hello George, and this is George. How the notice is served as well might be problematic if, for example, you need to serve on a registered office, which might be closed at the moment. And finally, in terms of ending the end of... Excuse me. That was got a moment. Sorry about that. And then in terms of the future of offices, lots been documented about Jess Staley's, the head of Barclays, comments at the end of last month that we are looking at the end of big city offices, and many employees having stress tested over the last 2 months, working from home, may well want to continue that on a temporary, permanent, flexible, short-term basis. But from my views, for what it's worth, while this may mean fewer workers in the office at any one time, in my view, the argument for offices remains. It remains the best for team working, sharing of ideas, collaboration, learning and development, supervision, and perhaps most importantly of all, shaping and company culture and values. So I think the office is here to stay. That's it for me, and I'm handing over to James, perhaps.
Thanks, Ed. I was just going to talk a little bit about how the pandemic and the lockdown restrictions have affected construction sites up and down the country. I think it's fair to say there was initially quite a bit of confusion about the extent to which the lockdown restrictions in particular would apply. And the kind of view among the construction sector was that they were the unsung foot soldiers, really, of the whole pandemic, to sites before the rest of us were even thinking about going back to the office. And I think really it became clearer that the economy just simply couldn't survive unless construction carried on. So that seemed to be the pretty clear motivation for getting construction sites up and running as quick as we could. Initially, as I say, the sites up and down the country were closing down, at least temporarily. And certain crazy clarifications on how the lockdown restrictions applied, culminating in a request to keep workers at least 2 meters apart wherever they could, but if they couldn't, it was just to be limited to 15 minutes at a time. So nobody really understood that. Perhaps they thought people could hold their breath for 15 minutes, but it wasn't very clear anyway. It is now sufficiently clear that construction sites are supposed to be up and running. And to say that, except in the most exceptional, that's the case. So what approach have we seen contractors take? Mixed bag, as you can probably imagine. Some have been very collaborative with employers, been quite open and honest with them. Some have been spectacularly aggressive, trying to abuse situations, give the nail extension of time claim to absolve them of any delays in the project. And similarly, when we look at the approach to develop times, where you see the best and the worst of people, to be honest. So looking really what's the legal position in all of this? As I said, we had some confusion at first about the extent to which the restrictions applied. But that the lockdown and the restrictions and the effect it's having on supply of labour and materials will be treated under most of the contracts that people are grappling with at the moment as a force majeure event. And there's probably also an express provision in the contract which people are relying on, which would treat all of this as the exercise by the government of powers. Now, most of the contracts that we've been dealing with are based on what's referred to as a JCT standard form, which is a standard form suite of building contract. And in that situation, the force majeure event and the exercise of government powers would give contractors an extension of time for any delay, but it wouldn't give them any extra money. And that's been the main thrust of the issues that we've been experiencing. Because as you can imagine, on construction sites, as they try and get them mobilised again, it's been extremely expensive. Now, we've seen some contractors be very candid with their employers, writing to them in very frank terms, explaining that these financial problems are something that they need some help with. That does rely on a quid pro quo approach from the employers. So what are the commercial and practical solutions here? Well, the biggest one has been, there's a clause in a lot of these contracts which has never been deployed before, which allowed parties to terminate at will if the works were suspended or substantially suspended for 2 months. That risk seems to have been removed now from all but very few sites. As I say, most are up and running. That was a pressing concern for most employers. But as that's been alleviated, we're now seeing a lot more collaborative discussions, and I think that's the solution. We need employers and contractors to work together more than ever on this. And as part of this process, there needs to be full transparency from the contractors as they show the employers what efforts they're making to mitigate delays, get the sites back up and running. And I think it's only with that collaboration that we're going to see what we need to see, which is sites fully functioning and safe, first and foremost, for their staff, especially in these inner city areas where we've got really congested sites at the best of times. We need to have that continued collaboration between the parties. And it's only as a result of that that as we come through it, we will start to see the disputes that are going to be inevitable as people argue over how much time they should have, and how much money, if any, they're due. We're going to have had that transparency so that we can resolve those. But it's already started. We're starting to see those disputes coming through. Certainly a very, very challenging time. But on the whole, been commendable. People have mobilised so quickly to get a lot of these sites running. So that was all I was going to say about it. I'm not sure what the running order is now. Apologies. I think it might be John.
I think, James, it's actually me. So if you can all hear me, I'll crack on. So my name's Ed Foulkes. I am a corporate partner at Clarke Willmott. Catherine, would you just put your hand up? just to confirm, you can hear me okay on the microphone?
Yeah, we can hear you, no problem.
Right, brilliant. Okay, so first of all, an apology. As you can see, my camera's not working. That's a shame, because I thought that this was fancy dress, and I prepared accordingly. So you can't see my dinosaur outfit, but never mind. You know, when this is all over, maybe I'll do a roadshow or something like that. So yeah, I'm a corporate partner at Clarke Willmott. In normal times, I would spend the bulk of my working time doing mergers and acquisitions, selling and buying businesses. Not surprisingly, there's not an awful lot of that going on at the moment. It's not completely dead, that market. There are deals being done. They tend to be in defined sectors, and those are the sectors that you would expect. So healthcare is very popular at the moment, as is technology. But a lot of the normal sectors that have been very buoyant over the last few years, there's very little happening. Chris Keane alluded to the fact that he thinks there may be an increase in deal activity as we hopefully accelerate out of this, and there are perhaps cheap assets on the market available for funds. I think that's almost certainly right, but I don't think we're quite there yet in the cycle. So the rest of my work normally is made up of some investment work, so we'll act for investee companies, investors, management teams, and some what you might call company reorganisations of one sort or another, whether that's returning money to shareholders or reorganising groups to de-risk or for some sort of tax reason. And we are seeing a lot in those types of work. So what I thought I would do just in this short section is talk a little bit about that and what we're seeing and what's available. I'll deal first with the debt options, some of which have been subsidised by the government, as you all know. I'll just deal with those quickly because this is fairly well trodden ground. There's quite a lot of information available, but the most sort of salient of those options are the coronavirus business interruption loan scheme, which is for smaller companies with a turnover up to 45 million, so not that small. The facilities available are up to 5 million advance, and the terms of the government guarantees the bulk of the loans to the investor, 80%. There's also a scheme for larger companies, which is up to 200 million, and that is dependent on the turnover of the company. You'll also see some later in the cycle, the bounce back loan scheme was launched, and that is for facilities up to 50 million, dependent on turnover, and again the government guarantees 80% of the loan. However, what I want to sort of spend the bulk of the time now talking about is the possibility of equity investment. I'll talk about why that is and one of the newest schemes that's available. You do see with equity investment some of the same issues that you see on M&A. So investors are very sensitive about sector at the moment and will due diligence very carefully. So the sort of things you need to be concerned about if you're an investee are the effect on your existing investors, how they integrate with the new investors, and what rights they have. Equity fundraisings, obviously the big advantage it has over debt is that it doesn't impact on the balance sheet to the same extent. It goes on the asset side of the balance sheet. So where there's existing debt in an investee company, it can be very attractive. Obviously, it's diluting the existing investors, and they will likely include the management team, so you do need to be alive to issues about whether the managers are sufficiently incentivised, and that might be something that you can look at going forward. As I say, if there are existing investor relationships, an investment agreement giving rights to existing investors, there needs to be a conversation about how that's going to dovetail with the rights for new investors who will normally expect more. And there will need to be, typically there'll be preemption rights for existing investors, so you need to allow time to deal with that or to get them waived. The other thing I just thought I would talk about briefly then is the Future Fund, which is a government-sponsored scheme which was launched on the 20th of May. So that is a scheme where essentially the government will make convertible loans to typically high growth companies, but not necessarily high growth companies. So initially it's a loan, but it's convertible into equity, and the expectation is that the loan will convert. The loans available are between 125,000 and 5 million, and it must be matched by funding from private investors. So it's not a defined scheme on its own. It can only be used in conjunction with matched funding. It's available only via a single lender at the moment, the British Business Bank, and there is information about the scheme on their website. And currently the scheme's only open until September 2020, although you would expect that date to be extended. Some other criteria for eligibility: the company must have raised at least £250,000 in the last 5 years from other investors, and it must be UK based. The test is either the majority of the employees are based in the UK, or the majority of sales are made in the UK. So it's a UK scheme only. It is not cheap money. So the interest rate on the loan is 8%, which rolls up until conversion. At conversion, the investor expects a 20% discount to the equity price on conversion, which is pretty punchy by comparison with what you might see in the private sector. And if the loan is redeemed rather than converted, there's a 100% redemption premium. So it's not for the faint-hearted, but I think it's a fair assumption that if this scheme is successful, and there has been quite a lot of interest in it from what we've seen, it will result in the state owning quite significant stakes in quite a lot of private companies. That's all I wanted to speak about. I can see there is a question on the Q&A, which I will address in a second. But if there's any other questions, more than happy to answer them. And I think you can see my picture and my contact details on the screen. So the question has just disappeared, but it was about healthcare, in particular dentistry, which is a sector where we do quite a lot. So just a sort of general comment, that is a sector that we've seen a lot of deal activity in. There was a definite hiatus for about 2 or 3 weeks where obviously dentists are, I think, still they can only do emergency surgery. They can't do their normal work. But the government very quickly stated that the income of the practices would be maintained, notwithstanding that practices couldn't operate as normal. The suspicion was a lot of the dentistry staff would be asked to go and work in Nightingale hospitals, for example, to work out elsewhere in the NHS. That hasn't happened to the extent people expected, but because the income has been maintained, there's definite interest from buyers and sellers. those transactions do take a little while to do, primarily because the consent of the regulator is required. But that sector seems to be very buoyant as far as I can tell. That's everything I wanted to say, but as I say, I'm very happy to take any questions, as are my colleagues.
Anna, you're on mute.
Oh, sorry, you're very lucky to have a double dose of me this morning, although not so lucky that my colleague John Flint, who's a specialist in commercial disputes and commercial litigation, isn't able to be here. But I just thought I'd tell you a little bit about what's going on in the court system to cover off what John would have said. So if any of you have any litigation in the courts or tribunals at the moment, you'll know that there's been lots of delays. The courts are trying to be flexible in terms of remote hearings, videos and telephones, e-bundles and data rooms, trying to be business as usual. The tribunals have had a stay over everything from the period of March really to the end of June, and things are just starting to come alive now. Certainly in the tribunals we're seeing massive delays with perhaps 3 to 5 day hearings not being listed for a year or 18 months time now. There's a much more flexible approach to settling disputes in the court system with remote mediations, and the same in employment tribunals. You can do judicial mediation via the telephone now. You can still issue claims online. You can still respond to claims if they're sent out to you. And the key message is, if you have a claim that you need to issue, to get in there quick to avoid lengthy delays. That's all we wanted to say on the subject. So if anyone has any questions, we'd be happy to answer them. I can't see any at the moment. No? I think that is going to end our session this morning then. It's been really good to have you all with us. Thank you so much. Our contact details are on the slide there, so if you do need any support or any questions come to mind after today, please do give us a call or drop us a line. And thanks very much for listening. Bye.
Thanks, everybody.